Hi, I'm Sara Bronin. I created this series to help you understand the basics of property law. So we are in Property Law 101. Today, we're covering the fourth question in the series about holding interest in property and about whether government may or may not take those interests away. We're focusing on the aftermath of a 2005 U.S. Supreme Court case, Kelo versus City of New London. Usually, when a case is decided by the Supreme Court, it trickles down to the lower courts, and those lower courts interpret and apply the holding of the case. With Kelo, you saw a reaction that went far beyond the courtroom. To understand why, I should take a moment to just refresh our understanding of the case itself, which is covered in full in another video. It involved a city's decision to exercise eminent domain to acquire properties across a few blocks to clear the land for a planned development proposal. Several plaintiff property owners, upset by the decision, sued, claiming the exercise of eminent domain was unconstitutional because taking property for private development could not be a public use as the takings clause requires. Those plaintiffs lost in court, but their lawyers were really savvy. They took their client, and one in particular, Suzette Kelo, a working class homeowner, on a media tour. They got the general public very angry about how governments could take property, even though such takings were anticipated in the US Constitution, and several other US Supreme Court decisions going back 60 years actually had very similar outcomes as Kelo. Those outraged by Kelo felt that the courts failed to protect landowners with judicial remedies, with too much deference to local governments and inconsistent takings analysis, particularly between federal and state courts. So, what do you do with all of these angry people? What happened was about 2/3 of state legislatures all over the country started enacting legislation to curb what they called eminent domain abuses. You even saw a few ballot measures brought by ordinary people doing the same thing. Generally speaking, these new laws granted more protection for property rights than are available under the US Constitution. They aim to constrain findings of public use and constrain government takings. For example, some laws said that only blighted or dangerous property may be taken, or that the government entity must prove that there is no alternative to achieving the public purpose but to use eminent domain. Some laws even say that the only public use is public ownership or literal use by the public. There may have been good and valid concerns that gave rise to this kind of legislation. To be sure, some uses of eminent domain have been very problematic. Eminent domain has been used to clear low-income and minority neighborhoods to create highways or to build large-scale urban renewal projects. That was certainly the case in the facts surrounding Berman versus Parker, a mid-century Supreme Court eminent domain case discussed in another video. It also should give anyone pause when a homeowner, especially one like Suzette Kelo, has a perfectly fine house taken away. But on the other hand, many believe that state action is an unwelcome response to the Kelo decision. The reason is that sometimes eminent domain can be used for good. Smaller municipalities like New London, which are strapped for cash, can use their power of eminent domain to help private parties assemble sites and make investments. Eminent domain has also been used to acquire important properties, from historic battlefields to conserved lands. So, although these are heated issues for the landowners and property rights movement and environmentalists, I should add, I think that there is probably less at stake after the Kelo decision than both sides realized. First, the Berman and Midkiff decisions made very similar findings regarding eminent domain for the 60 years preceding Kelo. In reality, Kelo was nothing new, but the alarmist approach of Kelo's attorneys has gotten a lot of attention. Second, regulators are likely to be constrained in choosing to condemn property by both political and financial forces. That said, This is a very tricky issue, one which, like many in this series, have had entire books written about them. But hopefully this conversation gives you at least a preliminary glimpse, a running start to understanding what the complex issues entail. So I will leave it there. I'd love to hear from you on Twitter or through my website where you can sign up to my mailing list. And I will see you next time.